Distinguished colleagues, thank you for the opportunity to present this work. My name is Antonio Sandu from Ștefan cel Mare University of Suceava in Romania, and the title of my paper is Dualities of Informed Consent, a critical examination of formalism and patient autonomy in Romanian medical institutions. Over the next few minutes, I would like to argue a single central claim that informed consent is far more than a process and far more than a form, that in its essence it is an instrument for the protection of human rights. Let me build this argument step by step. We usually see informed consent in one of two ways. The first is consent as a process, a deliberative encounter between physician and patient, a conversation that unfolds in time. The second is consent as a document, a form to be signed, filed, and, if necessary, produced in court. Both ways are true, but we contend that neither reaches and the essence. Beneath the process and beneath the form lies something more fundamental. Informed consent is, above all, an instrument for the protection of human rights in medical and research alike. This is the claim from which everything else follows. The process and the form do not constitute informed consent. They derive from this primary protective function. And why does this matter in practice? It matters in this way. First, for drafting, it changes how consent form must be signed, but must be designed. They can no longer be a simple ticked box. Second, for liability, it changes how courts assess medical responsibility. And third, for dignity, it restores the patient as a therapeutical agent rather than a passive acceptor. Where does this protective power come from? We draw on three intellectual currents that converge here. From Gergen social constructionism, the very capacity to consent is socially constructed, socially negotiated, and its content shifts with the community, within the community that defines it. From Beauchamp and Childress, principism, consent is anchored in the respect for autonomy, one of the four fundamental principles of bioethics. And from Fedden and Beauchamp, the ideas of autonomous authorization through consent. The subjects permit another person to act upon their own body. Together, this give informed consent a clear vocation to bring symmetry to a relation marked in its very nature by professional authority. I come now to the heart of the paper. We argue that informed consent, formally a waiver of bodily integrity, and this waiver is expressed voluntary, temporary, and partial. The patient give up part of one's rights in favor of a right they consider superior, their health or their life. Consider an invasive procedure. The patient may accept the removal of an organ, an amputation, even the risk of dying during surgery, because without the intervention, they would lose more than their consents to lose. In research, the structure is the same, but the superior right is a pursuit of social good, and precisely for that reason, participation in research must be exclusively voluntary. Here I must be precise, because the word waiver can mislead. Bodily integrity is inalienable. I cannot be ceded. It cannot be sold. It cannot be extinguished. the right itself never leaves the patient. So, what does the patient actually do? The patient exercises a right to disposition over their own body, expressly, partially, temporary, under condition fixed in advance. What circulates is only the permission to act. Romanian law illustrated this well. Article 64 of the Civil Code allows interference with the body solely for medical purposes. The sales of organs is prohibited. Purely aesthetic amputation are forbidden. Disposition is real, but it is functionally limited and always subordinated to a therapeutical purpose. If this is a waiver of a right, what kind of legal act carries it? We contend that is an unilateral juridical act and not a contract. In a contract, two parties consent and obligation bind both sides. But here, only the patient is asked to consent. The patient signs, the patient waives. The physician duties does not arise from the patient's signature. It arises from a different source altogether, from the law, from professional deontology, and from the institutional context in which the physician works. The distinction may seem technical, but as we shall see, it carries very real consequences. Now, calling this a unilateral act does not make the patient passive. Unilaterally concern only the form of legal expression, not the dialogue that precedes the signature. Before consenting, the patient is entitled to seek a second opinion. The patient is entitled to choose between therapeutical pathways where alternatives exist, and the patient is entitled to propose modification of the treatment that is offered. The patient, in other words, is an agent, never merely some who accept. Here is the first major consequences. The nature of the legal act reshapes the nature of medical liability. If a consent were a contract, the physician would own an obligation of result. The outcome would, in effect, be guaranteed. A cure would be presented to follow from the agreement. But if consent is unilateral act of the patient and the physician's duty flows from professional status, the physician owes an obligation of diligence to apply knowledge in good faith within institutional limits, with no cure guaranteed. Romanian case law confirmed this in the case of D.I. against N and Dr. R.I.N. The court held that physician-patient relationship is legal in nature, not contractual. Every rule worth stating has a revealing exceptions, and ours is non-curative medicine, above all aesthetic medicine. In curative medicine, a superior right is genuinely at stake, so consent keeps its protective vocation, and the obligation remains one of diligence. But when the curative purpose disappears, the relationship slides toward the contractual and the obligations slides toward results. French doctrine speaks here of a reinforced obligation of means and requires that the patient be informed, I quote, with a particular precision, clarity, and exhaustiveness. The exception does not refute our thesis. It confirms it. Consent protects precisely as long as there is a superior good for which the patient accepts the interference. Up to this point, the argument has been theoretical. We then ask a simple question: does Romanian practice match this protective ideal? To answer it, we analyzed 20 informed consent forms publicly available from Romanian public medical institutions, collected between September 2024 and February 2025. We read each form through a 4-axis grid adapted from the Beauchamp childless model. First, the character of the form, it processual or merely formal. Second, the information, it is clear and accessible. Third, the triad of risk, benefits, and alternatives. And fourth, revocation, is the right to withdraw mentioned at all and how. The findings are sobering. In most forms, the legal box is ticked, but real informing is rarely guaranteed. Consent has become an act of adhesion. We observe the 3 systematic deficiencies. The first is bureaucratic formalism, which refers to the very purpose of the institution. Protection of the patient turns into exoneration of the professional. The second is generic consent obtained on admission, signed before any investigation, so the patient consents to a treatment that neither party can yet know. And the third is the overlapping of consents, therapy, broad consent for biobanks and clinical teaching, all collapsed into a single form. This creates a real data protection risk, and too often refusal is not clearly separated from access to treatment. Is there a way out? We believe there is. Beyond the choice between broad and specific consent, plug and hole, purpose, meta consent, the subject chooses in advance what type of consent applies to each category of use and to each type of user. This is close to dynamic consent. Manson objects that meta consent, while permissible, is onerous and prefers a lighter a la carte model. Our position is firmer. Broad consent expires as methods and governance evolve, and to act upon an expired consent is to act without valid consent. If meta consent restores validity, then it is a remedy for a defect, not a luxury, and what restores validity cannot simply be omitted. Does the European Court of Human Rights support this reading? It does, though indirectly, since it evaluates the right to health through Article 8, the right to private life. In Trauma against Romania, the court addressed the failure to inform a patient of a foreseeable risk in a pregnancy termination procedure, after which a hysterectomy followed. In Autonomy against Romania, it addressed an involuntary psychiatric admission and medication given without valid consent. In Mocute against Lithuania, it addressed the disclosure of psychiatric information to the patient's mother without consent and without a clear legal basis. Read together the Article 8 test: interference, legal basis, necessity, proportionality is the procedural codification of respect for autonomy. Let me close with 3 concrete proposals offered the referenda that is a recommendation for future law. First, a reflection period, at least 24 hours between informing and signing for elective procedure where urgency does not require otherwise. Consent given immediately after information is consent given without deliberation. Second, an administrative disjunction. Therapeutic consent must be separated from research, biobanking, and teaching to distinct form, each stating clearly that a refusal does not affect the right to treatment. And third, specific consent. Generic consent should be replaced by consent specific to each medical act, renewed whenever the therapeutic approach changes. At the very last, at a disciplinary offense. That brings me to the end. If I may leave you with a single thought, let it be this. Informed consent is not a formally to be completed, but a right to be protected. Thank you for your attention. I look forward to your questions and your remarks. Thank you again.